welcome to this EU delegation sponsored Facebook live stream about the EU settlement scheme and EU citizens' rights in the UK. My name is Chris Ben. I'm an immigration lawyer with a firm called Seraphis. I'll run through sort of presentation. We try to pick up on the most important topic. Okay, we call it sort of myth busting because it covers the like I say, the sort of popular questions that we receive to via our kind of social media channels. So in terms of those who are still waiting for decisions, so there are basically at the moment, based on the last set of statistics we had, there's about 330,000 applications that are still waiting for a decision from the Home Office. So quite a lot of decisions, even though many millions of decisions have been made, there are still many with awaiting the outcome of their applications. So what does that mean for you? It means that whilst you're waiting for your decision, that you have what's called sort of temporary protection. So you should be able to carry on as you were with your right to sort of work, to stay living in the UK, to continue studying if you're at school or university whilst you wait for the outcome. So nothing really should change for you. Now, you should hopefully, when you apply to the scheme, have been granted or issued with something called a certificate of application. That's very important that you have that, because it's the way that you can prove that you have an application with the Home Office. Now, a lot of these applications are digital, and so you can sign into a Home Office account, and that you can see your certificate of application there. So that's the way that you can show that you have an application with the Home Office and that you're waiting for a decision and that you have all your rights whilst that happens. For most people, the application deadline for the settlement scheme was actually in June last year, the end of June last year. But quite a lot of people have actually missed the deadline. So many tens of thousands of people have actually applied after the deadline, according to the statistics. So what happens for those who've missed the deadline? Well, it's important to understand that missing the deadline, it's not ideal, but it doesn't mean that your application won't be processed. The Home Office is still processing these applications, and they will still assess you. They have to take into account the reason that you missed the deadline, which you'll be asked to explain when you make your application. It will ask you what the reason was. In a meeting I had with the Home Office this week, they said probably the main reason, there's two main reasons they actually sort of said that they've seen about people missing the deadline. One is for children whose parents weren't aware that they needed to apply, and also for those who just didn't know that they needed to make an application, and so simply just weren't aware of the requirement. And that's the sort of main reason they're seeing. And so, as you can see, and they will accept this as a reason. They won't. They'll still look at your application and they'll issue you a decision like they would do in the same way that someone applied before 30th of June. So you can still get status under the scheme even if you missed. And if you still haven't applied yet, please do apply as soon as possible, because it is important to make sure that you do get your application processed. But even though we're 6 months beyond the deadline, the Home Office will still accept the application. For those people who have lived in the UK for a long time, do they need to apply? Some people think that sort of they don't need to apply if they've been living here for sort of a number of decades. And the answer is it may be they are able to not apply to the scheme because they have an immigration status already. In some cases, they might not have an immigration status, even though they've lived in the UK for a long time, in which case they would need to make an application. And as I say, it would be a late application now. But it all depends if you have what's called sort of an alternative immigration status, and it would need to be one that's called indefinite leave to remain to avoid having to apply to the scheme. But if you don't have anything that shows you have an immigration status, then it is important to apply to the scheme as soon as you can. Lots of people have had an issue with renewing passports and identity documents. There's been some sort of difficulties. There has been lots of passport applications made recently. Some of it's because of the scheme, some of it's because of COVID and not being able to get a new passport issued. So can you still apply, or do you have to wait for a passport to be issued? What should happen is you should be able to apply using an identity document like a passport or a national identity card, even if it has passed its expiry date, because the system should still allow you to apply. And then what you would be asked to do in some cases is to send the Home Office the ID. Sometimes you can still use the scanning app with even if the document's expired. If you do not have a document at all, if you can't get anything to show your nationality or your identity, then you have to call up the Home Office and ask them to send you a paper application form, and then you will make an application, you make a written application, and you explain to the Home Office why you can't get an ID document issued, and then they will process you as a sort of a paper applicant rather than the online application that most people use. Should anyone worry about this thing called comprehensive sickness insurance? Now, you may heard about this, but if you haven't heard about it, what it is it was something that people, European nationals under free movement, were supposed to have comprehensive sickness insurance if they were, for example, studying at university, or if they were considered sort of economically inactive, so something like a retired person. And they were supposed to have comprehensive sickness insurance. Now, the UK didn't really implement this requirement very strictly under EU law, so most people have never even heard of it and didn't make any effort to obtain sort of this sickness insurance. So under the settlement scheme, the approach of the Home Office is to say it doesn't matter. It doesn't make any difference to your application if you did or didn't have comprehensive sickness insurance. So it's not something that anyone needs to worry about when they make an application. There's a second question which usually comes with comprehensive sickness insurance, CSI as people tend to call it, and that's about, does it matter if I want to become a British citizen, as people are entitled to do. Once someone has settled status, they can apply to become British after if they meet the criteria. If they want to, there's no requirement to, but if you wanted to consider making an application, then you can certainly do that once you've obtained settled status. Does CSI matter in that situation? It can do, because it is something that you're asked about in the application if you were, for example, a student, or if you weren't working, like if you were retired. If you're working or if you're self-employed, it doesn't make a difference because you don't need to have health insurance. But if you were, like I say, a period of studying, it is something that you may need to cover in the application. But I think the thing that I'd say is a general point, because we can't really go into all the details here about British nationality, is that there are very specific criteria for becoming British, and they're very different from the settlement scheme. So if it's something you are thinking about becoming British, it's a good idea to check with a nationality expert to understand the criteria, because it costs a lot of money to become British. So you wouldn't want to make an application if you didn't think that you were going to succeed, because you'd lose all the money that you pay to the Home Office. So it's not just about CSI, it's about making sure, if this is something you're thinking about doing, understanding the rules to becoming British. Do people with pre-settled status automatically get granted settled status once they've been living in the UK for 5 years? The answer is no, because the Home Office system and the way the scheme works is it requires you to make a second application to get settled status once you've meet the qualifying criteria. And so it is important to make another application if you're one of there's 2.5 million grants of settled status. That might not be 2.5 million people, because some people have applied more than once, but it's a lot. There is a lot of people with pre-settled status who will need to at some point make another application to the scheme. So it's important to know that it doesn't convert automatically into settled status. When you are thinking about transferring from, or upgrading, if you like, from pre-settled status to settled status, you need to show the Home Office that you've now got 5 years of qualifying residence in the UK. because that's the condition to get settled status. And qualifying residence means that in the 5 years that you're relying on for your settled status, that you haven't been away from the UK for more than 6 months in each 12 months. So essentially you're here in the UK for the majority of the time. You're not away for more than 6 months. Because if you spend too much time away from the UK, then you're considered to have broken your continuous qualifying residence, and that means that you can't be granted settled status. Now, there are a couple of things to be aware of. One is that within those 5 years, you are allowed to have a period outside the UK that goes over 6 months, as long as it doesn't exceed 12 months, if it's for what's sort of described as an important reason. Now, there's lots of important reasons that it could be, but some examples of an important reason to have that longer absence of up to 12 months would be something like if you were at university in the UK and you were had a year abroad as part of your course. That would be a reason for you to have an extended absence, because studying is considered a good reason. If you were, for example, receiving some medical treatment overseas and you were away for more than 6 months, that would be okay, as long as it didn't exceed 12 months, because it's considered for an important reason. If you decided just you fancied sort of going traveling for a period and you're away for more than 6 months, that probably wouldn't meet the definition of an important reason, because it's considered to be something that you've sort of chosen to do over something that's sort of more important, if you like. So there's things to think about when it comes to extended absences. Now, COVID again is a bit more complicated, because people who've been away for up to 12 months because of the COVID health pandemic, that's usually accepted as an important reason. But quite a lot of people perhaps who've left because of the health pandemic have actually been away for more than 12 months, given that it sort of started in March 2020. So the Home Office has a special rule for COVID, which says in some situations, if you've been away for more than 12 months, you can still continue with your residence to build up for settled status. But probably in those cases, you'll have to explain to the Home Office in more detail why it was that you have been away, and what was it about your situation that meant you stayed away for more than 12 months. And it has to be because of the COVID-19 pandemic, according to the Home Office guidance on this. So it would be a bit complicated if you've been away for more than 12 months, but in some situations it will be okay. Sometimes we get asked questions for people who've sort of spent time in the UK in the past, but have left sort of probably a number of years ago, and whether or not they can still apply to the scheme. So an example that I saw quite recently was someone who'd spent a couple of years in the UK, but then they left in 2018 and they haven't been back since. And they said, well, I got a national insurance number when I was in the UK. So does that mean I can apply to the scheme? And the answer is no, because when you have spent time in the UK in the past, if you want to qualify, you'd need to have spent at least 5 years in the UK in the past, because that way you could apply for settled status under the scheme, because you've got a 5-year qualifying period. But if you've only got 2 years, then you would be applying for pre-settled status. But because you've been away from the UK since 2018, so like over 3 years in this example, you'll be considered to have broken the continuous residence, and so the Home Office won't grant you pre-settled status. So that's the situation if for someone who has spent some time in the UK but not enough time and they've been away for too long to qualify. But if you have in the past spent 5 years in the UK, you can often qualify for settled status as long as you've never been completely outside the UK for more than 5 years since you left after your 5 years of being in the UK, if you like. So within employers and other organisations like landlords in England and universities and banks for the purpose of opening bank accounts. What do they need to check? Do they need to see status? And the answer is yes, or they should do, to avoid having problems themselves with the Home Office, because since the 1st of July, employers would potentially get fined by the Home Office if they didn't check that someone had pre-settled status or settled status, or had applied to the EU settlement scheme. If you went for a new job for an employer, for example, they are likely to ask you to prove that you have the right to work in the UK, and that's done through your digital status and the share code that you can generate through the status. So most people will find that they're going to be asked by an employer, or as I say, a bank or the university, to show their status. So that's why people need to be aware of how to generate the share codes, which we'll touch upon in a minute. And as I said earlier, whilst people are waiting for their decision, if you're still waiting to receive your decision, then you are allowed to continue working, and all those other things I just described. Again, the employers, if you went for a new job, you would be asked to show that you have applied to the scheme, and that's normally done with the certificate of application. And most people have, when they apply to the scheme, they'll sort of create what's called a sort of UK VI account, so a digital account, which is linked to your email address and your telephone number. And so you can use this digital certificate of application to create a share code that can be given to an employer or anyone else who's asking for that code. So that's how you would do it whilst you're waiting for a decision. And then when all being well, once you've been granted status, then it's the same thing. You carry on with your digital Home Office account, but it changes to pre-settled or settled status once the Home Office has processed your application. But that's important to know, because people, like I say, people don't need to have an outcome on their application in order to show an employer that they have the right to work if they've got a certificate of application. A lot of questions that we have received in the last few months have been about traveling, and sort of some people might have picked up on reports in the newspapers about difficulties traveling or trying to get back into the UK. It's not usually a problem to leave the UK, but it can be a problem to get back to the UK. And part of this comes from the fact that digital status is quite a new thing, and so not everyone is always aware of the rules of how to use digital status. And I think we've particularly seen this with some airlines who don't seem to have the right information about how to process people with digital status. But in terms of being at the UK border, so at the airport, at the Eurostar check-in, it shouldn't be any issue, because the border force officers can see your status because it's a Home Office system, or you can enter through the electronic automatic gates, and you shouldn't have any issues there. It's helpful if your status and the identity document you're traveling on are linked to each other. So when you apply to the scheme, your passport or your national ID card is the document when the Home Office creates your online account, they link it to that document. So if that's the document you travel on, then when you come back in, the system should be able to see that, yes, this is the passport for this person who has settled status. If you use a different document than one you've applied with, then they wouldn't be able to make that connection immediately, because obviously the two things aren't linked. And in those situations, so again, the Home Office system should still be able to assess you, should be able to be seen, because you'll have the same name as as your digital status and the same date of birth, and there'll be a photograph of you. So they still can check that you have status even if you use a different document, but obviously that type of check would take longer than it would happen. It would happen very quickly if it's a document linked to your status. If it's a new one that you haven't yet linked, then it might take a bit longer at the border. So that's why we always say to people, like two things is, firstly, if you have more than one ID document that you travel with, so a passport and a national ID card, then it's a really good idea to link both of them to your digital profile. And when you change documents, if you get a new one, then try to update your profile with your new document as soon as you can, because that means you're able to they can see it when you travel in and out. Sometimes we get asked about how if you can have more than one document linked to your online account, because it doesn't, when you look at it, it doesn't seem like you can have more than one document, but actually the system does allow you to add in new documents. And so what happens is it doesn't forget the old document. So if your passport is the document you applied with, then you want to attach your national ID card, because sometimes you use that for travel. You use the online profile and you update your document, and the new ID card that you're adding doesn't squeeze out the passport. The passport stays there. It's just you can't really see it. So both documents are linked. The only thing to kind of think about with that is that when you want to log on to your account to look at it, the account always remembers the most recent document that was added to it, and that's the document that's used to log in. Because you'll know if you've logged in that you're asked for the ID number of the document linked to your account. And so, as I say, if you've added a new one, then it's that most recent document that you need to use the reference number from, because otherwise you won't be able to get in to the account. But that's how it works. But you can have more than one, and you should always try to add in any document you're traveling with, or any new document, new passport, new national ID card when you get it. On national ID cards, this is something where the Home Office did change their policy about national ID cards and traveling to the UK for European citizens who do not have status under the scheme, or who are not covered by what's called the withdrawal agreement. There are some other categories of withdrawal agreement beneficiaries who aren't under the settlement scheme. But the important thing is, if you do have status under the scheme, or if you've applied to the scheme, then you can carry on using your national ID card. There's no change for you. And this is it's a protected right under the withdrawal agreement. It's a protected right for life under the withdrawal agreement. There is a requirement by 2025 for the national ID card to be a biometric one, so it has to have a chip in it if someone wants to carry on using it. But as I say, it's something that you're entitled to continue using for life. It's another area where I think we have seen some sort of cases where airlines particularly have not understood that European nationals are entitled to use their ID cards still, after the Home Office changed their policy for those who are not under the settlement scheme. So sometimes people have had some problems, like we ask at from the EU delegation from the Facebook page, or the delegation's contact email mailbox, that if people do experience an issue, that they report it, because it's important to make sure that airlines are applying the correct rules and are allowing people to travel on their national ID cards if that's what they want to do and they're eligible. So that's the situation with ID cards. Where someone's what we would call a non-sort of European family member, so someone who's basically been sponsored to be granted status in the scheme because they're a family member. So you're a European, your spouse wants to get status, they can be sponsored by you to get pre-settled or settled status, which is excellent. But when they're granted it, they also do get digital status. So someone who is not European national will also have this UK VI account, They'll be able to see their digital status, and they'll be able to use the things like the share codes for the employers and for the university and the banks in the same way as a European national. But there is a big difference in travel, because the UK's border policy is still, well, the policy about airlines and people who bring people back into the UK, like the Eurostar or airlines or ferries, they are required to check that someone has the right permission to be able to come to the UK if they're a non-EU national. And so the airline is likely to ask to see a residence card, a physical residence card, if you are a non-European national with status under the scheme. And if you don't have that, then they are unlikely to let you travel, because they run the risk of being fined by the Home Office if they do let you travel. So this is really, so it's really important that people, you will either already have a residence card that you might have already been issued by the Home Office in the past before you apply to the scheme, or you get issued a residence card when you apply to the scheme and you get granted pre-settled or settled status. So you should be in one of those two situations. And if your residence card is expiring, you can apply to the Home Office to replace it. But the important thing is, do not travel outside the UK if your residence card has expired, is going to expire, or if you've lost it and you can't find it and you still want to travel, because you're going to have problems coming back to the UK. We've seen a number of cases where this has happened and people have not been able to get back into the UK because their card, they don't have a valid card, or they lost it, or something along those lines, and it's very distressing. And you have to then resolve the situation whilst you're outside the UK, which is very difficult. So yeah, so that's just a big kind of like red light, a warning for non-EU family members, and the need to carry on traveling with that card at the moment. As I said a bit earlier about late applications, it's been the case, as far as we've been informed by the Home Office, that there's been quite a lot of late applications for children, and that's probably down to a misconception from parents that children are just granted status because the parents are granted status, or maybe the child has been born in the UK and therefore think the child is British and doesn't need to apply to the scheme themselves. And so it's important to make sure that you know what the situation is for your children. It's possible, if they were born in the UK, that they might be British, because a child who's born in the UK where one of the parents has settled status would be born British automatically. They can apply for a British passport. But if your children came to the UK with you when you moved to the UK, or if your child was born, let's say both parents had pre-settled status and you have a child in the UK, that child is not born British. And so the children in that position do need to apply for their own status under the scheme, because they do need to be able to have status in their own name. They don't get it automatically just because their parent has got the status. So something to think about if you have children who came with you to the UK, or if you've had children in the UK since you arrived. You need to know what their position is to make sure, if they need the status under the scheme, that they've made an application. And this is so this is my example that I was giving, which is both parents have pre-settled status under the scheme. Would the child need to make an application? And the answer is yes, because neither parent is settled when the child is born. That child would not be born British, therefore needs to have their own status. And the rules say that the child has to apply within 3 months of their date of birth, which can be a challenge, I think, for a number of people, because it might be hard to get the child a passport within that time. Sometimes children can't be issued with passports in the UK, things like that. If that's the situation, then the Home Office wants you to make an application on a paper form. So you have to call up the Home Office and say, I've got a newborn child, I need to apply, but I don't have a passport for the child. and they should be willing to send you out a paper application form, and you can send that back and explain that the child, you're going to get a passport for the child, but you couldn't do it within 3 months, and that should be okay as far as the Home Office is concerned. But it is important to try to get the application in within 3 months. If you've missed that 3 months because you were waiting for a passport, then don't worry. Make the application as soon as you can and explain that you thought you needed to wait for the passport to arrive. Just a broad one-off point about healthcare, because it is something that we do get asked about a lot, is what's the situation with the NHS if I have status under the settlement scheme, or if I've applied? And the answer is if you're living in the UK and you've been granted status, or you're applying to the scheme, then you have, for it continue same way as before, you have access to the NHS for free. So there shouldn't be any change in the approach towards the NHS. The NHS in England certainly is able to check you have status using their system. So they don't, in theory, they don't need to even ask you to show it to them. They can check it, but it's always possible. Like all these automatic checks, is if they don't work, it's always useful for you to be able to show someone to access your own status, which is why we make sure people know how to do it, so that if it comes to it, you can show them. But they can check, in theory, they can check automatically. We do get a lot of questions from about which family members people can sponsor if they're not living here already. The withdrawal agreements protected sort of what we would call family reunion rights, so the rights to bring your family to live with you in the UK if they weren't here already. What we call them when we're talking about them as a kind of lawyer speak is we call them joining family members, because they're not here already, so they're applying to join you. It's important to know which family members, because not every family relationship is covered, and if the family relationship is not covered, then they can't be sponsored under the scheme. So I've sort of tried to list the eligible family members. This would be your spouse, husband, wife, your civil partner, an unmarried partner called durable partners under the scheme for some reason. Now, they're all eligible for sponsorship, but the key here is that the relationship must have existed by the 31st of December 2020. That's when the UK exited what they call the transition period. So the relationship has to have been in existence by that date to be covered. If you met someone on the 1st of January and you've married them on the 1st of January 2021, and you married them on the 1st of January 2022, they're not going to be covered by the scheme because the relationship didn't exist by the cutoff date. So you'd have to look at the other UK domestic immigration rules about that situation. Children can be sponsored, and that doesn't matter if they're born to you in the UK or born overseas, and it doesn't matter when they're born. Even if they're born after the end of 2020, they're still eligible. Children are considered dependent on you up until 21, so you just have to show that the child is your child and they're under 21, and that's fine. If adult children can be sponsored, but they have to be considered to be dependent, so somehow reliant on you for financial support or some kind of emotional, social support. That can happen. And same with what we call dependent parents and grandparents. So they can be sponsored under the scheme, but there is this requirement that they're somehow dependent on you as their sponsor. So as I say, that can be to do with finances, to do with the cost of living, wherever they are. If they're in sort of ill health and they're dependent on you, that would be another reason. And so you have to look into whether they sort of consider dependent to sponsor those relationships. But they're all eligible family relationships that can be sponsored. How it works is that they are expected, so not because they're called joining family members, the idea is that they're not in the UK already, they're applying to join you. And so what the rules say is that they need to make an application outside of the UK to prove that they're eligible, and they have to wait for that decision from the Home Office, and then once they receive the grant, they can then travel to the UK. So that's how the system is supposed to work. What we've seen happen is that sometimes family members have applied and they've decided that they got tired of waiting for a decision, and so they just travel to the UK anyway. And because European nationals are what we call non-visa nationals, so they don't need a visa to come to the UK as long as they're for the purposes of visiting. So essentially people have applied to the scheme but then turned up and entered into the UK saying they're visiting, or just through the automatic gates as visitors, and then they wait here to be granted status. Now the Home Office doesn't want you to do that, and it is problematic because if you applied to the scheme as a joining family member and didn't wait for a decision, and you then came to the UK and told an immigration officer, well, I haven't received my decision yet, then the likelihood is they'll refuse entry, and they'll say, well, you need to wait for your decision before you travel to the UK. So it can be problematic. You can be turned around at the UK border if you haven't waited for the decision. If someone's like entered and they're already here as a family member, and they didn't sort of know they were supposed to apply outside, then they can actually wait. They can apply whilst they're in the UK to be granted status, so they don't have to leave and apply from outside if they're already here. But generally, what like I say, what the Home Office wants people to do is they want them to apply outside the UK. They want them to wait outside the UK till they get a decision to join you. That covers family members who want to come and live with you, but obviously many people have family members who are not in the UK who might not be interested in coming to live in the UK but still want to come and visit and and to see the sights of the UK, in which case as EU nationals that's absolutely fine. As I sort of said a minute ago, there's no visa requirement for an EU citizen to come to the UK for a short-term visit, and a short-term visit in UK rules is under 6 months. So someone coming for a visit for under 6 months is allowed to enter without a visa, as long as they meet the visiting rules, which is that they intend to leave before 6 months, that they have enough money to pay for their trip, however long they're going to be staying here for, that they don't intend to do things like work in the UK. You can't work in the UK as a visitor. You can't do unpaid work in the UK. So you couldn't come to the UK and do some kind of voluntary internship either. That wouldn't be allowed, because the visiting rules say no. It's about you coming to visit your family. It's about you coming for tourism. It's about some short-term, very short-term sort of business activities can be undertaken, but it's very restrictive. But the point is if your family wants to visit you for a couple of weeks in the holidays, then they don't need a visa. I've said here at some point in the future, UK will be introducing what's called electronic travel authorization. So it's just something I'm flagging as a future thing. It doesn't exist at the moment, but the UK intends to ask EU visitors to get this travel authorization before they travel. It's sort of like a screening check about kind of criminal activities effectively. So anyone who's been to the USA will have probably applied for electronic travel authorization. So that it's the sort of a mirror of that scheme, but that's not there at the moment. Sometimes we get asked about what should someone do if they don't qualify for the settlement scheme, that, you know, if they have not been to the UK before and they're thinking about it, or maybe they came to the UK for a couple of years but left too long ago and can't get status. Can they, what do they want to do if they want to come and live or to work or study? So we're not talking about visiting here. I've just been through the visiting rules, but this is about actually staying on a longer term basis. And the answer is that you need a visa, because the UK doesn't work as a free movement country anymore. So there's no ability just to sort of turn up and get a job the next day and stay here, or to come in and enroll at school or university without having a specific visa for that purpose. So we have a very, very much more restrictive system now in the UK. And so I can't go through the kind of criteria for working visas or the student visas, but just to say that, like I say, that you have to apply for one before you come to the UK, because you have to tell the Home Office that this is your intention, it's to study, or it's that you've got a job that someone's sponsoring you to do in the UK and you want to come and work. So that's a requirement, and you need to apply before you come, and you have to be issued a visa in that specific category. So it is a lot more restrictive than it was under the free movement system. Okay, so that kind of covers everything that I wanted to, as the main questions that we get asked about. So that's come to the end of the questions that we've had, and come to the sort of end of the hour that we normally do this for. So hopefully that's informative for everyone who's managed to take the time, and thank you for the questions that you've submitted. So, as I say, very nice to see you. We do this on a monthly basis. So if you've joined for the first time, nice to see you. If you come back, nice to see you again. And we'll be back in March with another session. So thanks very much. Have a good evening, everyone.